The big event in bankruptcy this week was oral argument in the U.S. Supreme Court in the Chicago parking ticket cases to tell us whether the automatic stay is really as automatic as some of us think. The case is called City of Chicago versus Fulton, and it deals with the question of whether someone holding property of the estate must, shall we say, automatically release that property to the debtor upon knowledge of the filing of a bankruptcy petition. Here's how it all came down. Chicago impounds automobiles belonging to people who have failed to pay their parking tickets. Well, folks file Chapter 13 petitions. They go to the impound. They have the keys in the pocket and they say, listen, I'm here to pick up my car. But the City of Chicago said, no, you can't get your car until you pay your outstanding tickets. Well, bankruptcy judges in Chicago routinely held that holding the car was an act to control property of the estate and thus a violation of the automatic stay under Section 362A3. The Seventh Circuit affirmed, there was a split of circuits, and the Supreme Court granted certiorari. I listened to oral argument, and I must confess, I'm not sure what the result is going to be. To me, I think it's really rather simple. Is holding on to property after someone has asked you to cough it up an act to control property of the estate? To my way of thinking, and to the thinking of some of the justices, that surely is a violation of the automatic stay. But then some of the justices got all bound up in Section 542 and whether that has anything to do with the case. As I said, I'm not sure what the result is going to be. I think that Justices Kagan and Sotomayor are probably on the side of the debtor, as is Chief Justice Roberts. On the other side, however, I am guessing, based upon oral argument, that Justices Thomas and Alito are for the City of Chicago. Ordinarily, Justice Breyer is on the side of the debtor, but he asks some questions that lead me to believe that he may not be in this case. In any event, as I said, I don't know how it's going to come down. It very well may be a 4-4 decision. And of course, if it is 4-4, it means that the decision of the Seventh Circuit will stand and the disposition in the Supreme Court has no precedential effect. However, it is early in the term. If it is 4-4, as we sit here right now, keep in mind that there will be a new justice on the court, perhaps in a matter of a month or so. So I'm thinking if it's 4-4, then perhaps what we're going to find is that they order re-argument sometime in the early winter. The new justice will be on the bench, and the new justice can decide this very important case of federal bankruptcy law. I am Bill Rochelle, Editor-at-Large for American Bankruptcy Institute. I will return same time next week with something interesting that has occurred in bankruptcy, but frankly, I don't know how we top what we had with oral argument this week. Until next week, good day.